Hi and Assalamualaikum. Next, we will continue with the topic of marriage requirements. At the end of this topic, the students should be able to first explain all the basic requirements of a valid marriage as stated in Law Reform Marriage and Divorce Act 1976. Number 2, analyze factors which may vitiate the validity of a marriage. And number 3, apply the relevant principles of marriage into a real situation. In order to understand better for this topic, we have prepared a video illustrating certain situations relating to valid requirements in a non-Muslim marriage. So, let us watch the video first.
Good morning, Puan.
Good morning.
So before we tell you the purpose of we coming here, let us introduce ourselves first. My name is Lee Chong Chat. I'm a 16 years old student, and currently me and my partner studying in the same school.
Morning, Puan. My name is Sunini. And I'm now 16 years old also.
You are also studying in this school?
Yes.
Okay, so what is the purpose actually that you come here?
Actually, both of us want to get married, so we want to ask whether we are eligible to get married.
Okay, before we examine one by one, can I know certain particular details about you and your partner? Okay, first I would like to know whether you have any additional job or you just study?
No, currently we are only students.
Okay, thank you. And then how about consent? Did your parents consented to this marriage?
Actually, from my side, my parents didn't know about this relationship. I kept it as a secret.
My parents also didn't know that I have a relationship with Chong Chat. And then my parents did say that before they don't want me to enter into marriage before I finish my study.
Okay. So how about you yourself? Did you consented to this marriage?
Yes.
Okay. Okay, and you are female, right? So Nini, and you are born as a female.
Yes.
How about you?
Yes, I born as a male.
Okay.
No worries.
And you, both of you single?
Yes.
You did not enter into any contract of marriage before this?
No.
Okay, this is your first time. Okay. So I have looked at your details. For the first situation in the video, both parties are 16 years old. So, in order to determine whether they have fulfilled all requirements of a valid marriage or not, let us examine the conditions one by one together. For a marriage to be valid, it must fulfill two requirements, which are, the first one is lex domicile, which is capacity, and number 2, lex loci celebration. This is stated in Part 3 of Law Reform Marriage and Divorce Act 1976. For the first requirements of marriage, which is age, the minimum age for male is 18 years old, while for the female is 16 years old. This is stated in Section 10 of Law Reform Marriage and Divorce Act. Or if they are minor, which means that they did not attain the age as mentioned in Section 10, they need to obtain license from the Chief Minister. But what if the party did not comply with the condition of age? So in this situation, Section 69, Section B said that the marriage become void. In one Singapore case named Inderjit Singh and Jinder Paul, Section 9 of Women's Charters stated that any marriage purported to be solemnized under Part 3 of the Act shall be invalid if at the date of the marriage either party was under the age of 18 years, unless the solemnization of the marriage was authorized by a license granted by the minister. And in this case, even though the female party was 16 years old at the time of marriage, the court said that the marriage is considered as valid since they already obtained a license from the Chief Minister. The second requirement is the parties must not within the prohibited degree of relationship. So what is the prohibited degree of relationship here? Section 11, subsection 1 until subsection 4 have listed down all the prohibited degree of relationship in marriage, include one's own parent and also grandparent. However, there is one proviso under subsection 1 where a Hindu man can marry his sister's daughter, while the Hindu woman can marry her mother's brother. And there is also another exception under subsection 6 of LRA, where the Chief Minister can grant a license to a marriage under section 11 if it is unobjectionable under the law, religion, custom and usage of the parties. In the case of non-compliance of this condition, section 69 subsection C provides that the marriage will become void. And number 3, the third requirement is consent. Consent here referring to consent from parent or guardian and also consent from both parties in the marriage. For consent from parent or guardian, it was explained in section 12 of LRA where subsection 1 stated that the party to marry must obtain consent from the parent or guardian if the party is between 18 to 21 years old. And this consent must be made in writing form, and it may be obtained either from father or mother or adopted father or adopted mother or from persons in loco parentis. However, the consent is not required if the parties has previously married. Besides that, both parties must also consented to the marriage. According to section 37 of LRA, it is an offence to compel a person to marry or to prevent that person of 21 years from contracting a valid marriage, where the punishment are 3 years imprisonment or 3,000 fine or both. In the case if no consent obtained either from parents or parties to the marriage become voidable under section 70 subsection C and also section 70 subsection D. Then we move to the fourth requirement, which is the marriage must be a monogamous marriage. This has been mentioned in section 5 of LRA, and in the case if the requirement has not been fulfilled, the marriage will become void by virtue of section 69 subsection A. And it is a criminal offence for those who contracted bigamy marriage, as provided in section 7 of LRA, where the punishment are 7 years imprisonment and also fine. This is stated in section 494 of Penal Code. In the case of PP Rajapan, the fact stated that the respondent was married according to Hindu custom in India in 1947 to the complainant named Pelaniamal. In 1954, the respondent, complainant and their children migrated to Malaysia and their marriage was subsequently registered with the Registrar of Marriages in Malaysia. In March 1984, the respondent married one Saraswati in India and brought her back to Malaysia. The respondent then charged in the Klang Magistrate Court for bigamy. And then we move to the last requirement, which is the parties must be biologically male and female. In the case High and Woodman C, marriage was defined as a voluntary union of a man and a woman to the exclusion of all others, where section 69 subsection D provides that the marriage become void in the case of non-compliance of this section. And in the case of sex change operation, the court will look at the original sex of the person and not after operation, even though the sex of the person has already changed in the identity card. This has been further discussed in the case of Lim Ying Hiok Kian Ming Eric and Corbett and Corbett. To conclude, there are 5 requirements of a valid marriage for non-Muslim couple in Malaysia, which are: the first one is age. Second one is the parties must not within the prohibited degree of relationship. Number 3, consent. Number 4, monogamous marriage. And lastly, biologically man and woman. And in the case of non-compliance, it is become an offence as provided in Section 41, Section 3, where the parties will receive the punishment of maximum 3 years imprisonment and fine of maximum 5,000 ringgit. So, after understand all the basic requirements of valid marriage, what is your answer regarding the situation given earlier? You need to look at all the requirements one by one and apply to the situation given. Since the parties in the case given are minor, so they need to obtain license from the Chief Minister and get written approval from the guardian to proceed with the marriage.